Advocate Semenya.
Good morning, Chair. Good morning, Madam Commissioner. The lie of the land, according to our conversations with our fellow lawyers, is that we will commence the day with the 2 additional documents regarding 2 different buildings, with the object of having those admitted into evidence as exhibits. No different from the series of other documents we have dealt with so far. Today we're scheduled, though, to deal with the opening statements. The indications were initially that Sari was going to do one, so was MNS, so was the Human Rights. No? The 3 of them. We now know that despite...
Is the Human Rights making an opening statement?
Tomorrow.
Tomorrow.
That's right. So we expect the tribunal, to the extent that they promised they want to go that direction, to make one themselves. We regret the delay for the day, principally also because we needed to have some little time to look at the document filed today by Sari, to which we are grateful. MNS tells me that they will deliver a opening statement, but it would be an oral one with a written submission, oral opening statement to come later. I don't know when that is, but if you allow us, Chair, to commence with the moving of 2 documents to be admitted into evidence.
Yes, you may.
I beg leave that Ms. Platt deals with the 2.
Yes.
Thank you, Madam Chair, Madam Commissioner. May we go to the report, it's exhibit page 789, exhibit HPB 1 to 17, the last 2 reports at the end of the document. What page? 789.
789, I think.
Madam Chair, Madam Commissioner, this is exhibit HPB 1 to 17. It's on the High Point building. It was inspected on the 23rd of July 2024. On the front page, we'll see a picture of the exterior of the High Point building. Overleaf, we have pictures of the building entrance, fire extinguishers, the elevators that are out of order, a dilapidated basement, water damage on the ceiling, water pipes exposed, water damage again on the ceiling, electric meter box, and the ceilings damaged by water. The background, Wing Property Management Group owns the property. The tenants and property management are having disputes over building maintenance. There is a matter to be heard at the Housing Tribunal on the 6th of August 2024. Under observations, we have occupancy. The building has 330 units and approximately 4 people per family. The property has 28 floors. The residents at the property are paying rent, which ranges from $750 a unit, depending on the size. The rent has been subsidized by the government since 2004. Under facilities, the property has shared communal ablution facilities. The elevators in the building are all out of order. Utilities, paragraph 9, there is water in the building. There is severe water damage on the ceilings in the building caused by water leakages on the roof. The property has electricity and waste is collected in bins outside the building and Pick It Up collects. Under the heading fire, the building has fire equipment. Inputs from the parties, CIRI and ICF, state that the residents are represented by CIRI and that they agree with the findings of the Commission. The City notes and agrees with the position taken by the Commission herein. and they will issue notices of non-compliance with the bylaws as part of its bylaw enforcement duties. Vermaak has also seen Vermaak attorneys have also seen the reports, and they said based on the findings of the Commission, they have no further comments to be made. Under conclusion, factual finding, the inspection revealed that the building is prima facie fit for human habitation. Sorry, Madam Chair, Madam Commissioner, we can remove the "in that." Terms of reference. This property prima facie does not fall within the terms of reference in that it has not been abandoned or taken over by other groups. Basic services are provided and the occupiers are paying rent. Bylaw contraventions. There is prima facie evidence of contravention of the following bylaws. The City of Johannesburg Metropolitan Municipality Public Health Bylaws state in sections 19 and 20 that every owner of premises to which a municipal sewage service is available must ensure that all wastewater drainage pipes from any bath, wash, hand basin, toilet, shower, or kitchen sink is connected to the municipal sewer in an approved manner, and that no person may prevent, obstruct, or interfere with any sanitary service provided by the council. This property has running water in the basement and water damage in the ceiling. Possible recommendations: the building should be renovated and bylaw contraventions need to be regularized. On the next page, we have the album of remaining photographs and the video footage. We have a picture of the Standard Bank that's in the building, a view of the room, then the exterior and side view of the buildings with broken windows, and the water leakage in the basement. We also have, as the last two, exhibit number 16 and 7, the link to the video footage. If there are no objections, Madam Chair, Madam Commissioner, may this be admitted into evidence as Exhibit HPB 1 to 17.
Exhibit HPB 1 to 17 is admitted into evidence.
Thank you, Madam Chair, Madam Commissioner. The last report is Exhibit 51V 1 to 7. This is the report of 51 12th Street, Vredendorp. It was inspected on the 23rd of June 2024. On the front cover, you'll see it is a vacant lot with cars. Then we have on the next page a tent with solar panels, a dustbin, a heap of waste. Background: 3 people live on the property. They live inside the parked cars. Observation: structure, there are only cars, a tent, and no house on the property. Therefore, no real observations could be made on the structure. Under rental, occupiers do not pay any rent. The property has no ablution facilities. There's no water in the property. Occupiers get water from a nearby taxi rank. There's no electricity, but solar panels are on the tent's roof. For cooking, occupiers use braziers. There is a dustbin on the property, and there's a heap of waste which poses a fire hazard. Input from the parties: SIRI and ICF state that the residents are not represented by SIRI or organized by ICF. They agree with the findings of the Commission, and the residents should be moved to adequate TEA. The city stated that they may engage the occupants for a consensual moving of the occupants, failing which the requisite legal proceedings be instituted to move the occupants, and they will determine if there is a temporary emergency accommodation to which these occupants can be moved. Conclusion: factual finding. The inspection revealed that the building is prima facie not fit for human habitation, in that there are no ablution facilities, no water, there is no proper housing. Terms of reference: the property prima facie falls within the terms of reference in that the property is abandoned, indigent people occupy it, and there are no provision of basic services. There is no provision of basic services. Bylaw contraventions, paragraph 14. There is prima facie evidence of contravention of the following bylaws: City of Johannesburg Metropolitan Municipality Waste Management Bylaws, section 46.3 states, no person may dump waste. Possible recommendations: the city must consider using the property for a new style temporary emergency accommodation. We have one more photo on the next page, which is the car workshop station, as well as a link to the video footage. Madam Chair, Madam Commissioner, if there are no objections to this exhibit, may it be admitted into evidence as Exhibit 51V 1 to 7.
Exhibit 51B 1 to 7 is admitted into evidence.
Thank you, Madam Chair. Madam Commissioner.
Chair, regrettably over the weekend, there was a fire to one of the buildings that the commission inspected. On the positive side, I'm advised there was no loss of life in this fire. I'm making the announcement because I would request MNS to take note that we would request a further supplementary affidavit of the fire chief, Mr. Munacheng, principally aimed at a very narrow scope. One, to advise the commission since Usindiso how many other fires have happened and what the city has done in respect of those fires. And secondly, to give us a much more fuller report as facts are known about the fire of the 19th of October 2024 being the past Saturday. I know that a series on the ground. If they are so minded, they can advise you, Chair, and Madam Commissioner, what has come to their knowledge so far.
Yes.
Whereafter we would have Mr. Brickhill give the opening statement for SERI.
Yes. Mr. Koza? With regard to the request for Mr. Munacheng's supplementary papers, what do you say?
Good morning, Chairperson. The request is noted. We will endeavor to comply with the request.
Okay. Okay, fine.
Chairperson, we intend to make only one submission in our opening statement, and that is in relation to the terms of reference of this commission. Other relevant issues, we intend to address them in our closing submissions. As we understand the proclamation notice, Part 2 of this commission is concerned with investigating hijacked buildings or the phenomenon of hijacked buildings. Now, a building qualifies as a hijacked building if it meets the following requirements. Firstly, it must have been abandoned by its owner or a landlord. Number 2, it must have been taken over by a criminal syndicate or other group. And lastly, it must be leased out and populated by indigent tenants. We submit that during the inspections in loco, the commission inspected buildings that do not strictly fall within the parameters of the terms of reference. After the inspections, the evidence leaders also issued 6 reports making recommendations as to what must be done in relation to the buildings that do not fall within the terms of reference, meaning those were not hijacked buildings. But regardless of that, evidence leaders are making recommendations as to the steps that must be taken in order to address the challenges that are faced by the occupants of those buildings. We admit that during the investigations, indeed, buildings that can be identified as problematic buildings in terms of the COJ bylaws were inspected and clear difficulties were observed, and it is required that action be taken. However, it is not for the scope, within the scope of this commission to address those challenges. In our view or in our submission, it will suffice for this commission in its report to record the observations made in relation to the buildings that are not hijacked, and that a recommendation be made for the Premier to take steps to address the challenges faced in those buildings. However, it is not for this commission to now address the specific challenges faced with those buildings. Otherwise, the commission, in our view, will be ultra-virus because it will now be going beyond its scope should it concern itself with buildings that are not strictly falling within the parameters of hijacked buildings.
Yes.
Chairperson, that is our submission that we make.
When do you hope to file your opening statement?
We do have a draft. We can file our opening statement within the course of this week, Chairperson.
Within the course of this week?
This week, yes.
Are you not making your opening statement tomorrow?
No, this is our opening statement,
This is your
Commissioner.
opening
Yes,
statement?
yes. We seek to deal with only one point, which relates to the terms of reference of this commission or the mandate of this commission. So the remark I've made is all that we want to make. And perhaps to add, on 21 October, we had written to the evidence leaders, and we did express this concern that we feel that the commission is going beyond the terms of reference. So we then felt it would be appropriate for us to also put this issue on record. But other than that, it was not our intention to make opening statement. We had sought to only make closing submissions, but we felt for record purposes, let us articulate this concern that we have.
I suppose this point will be aptly argued comprehensively in your closing argument.
Yes, we will do so, Madam
Yes.
Chairperson. Thank you.
Thank you. Mr. Bricky?
Good morning, Chairperson, Madam Commissioner, and to our colleagues. Chairperson, I will begin just by dealing with the issue of the fire incident over the weekend and share what we know at this stage.
Yes.
From the SERI and ICF's side, we will also provide further details and, if necessary, a statement on the incident at that building. The building in question, Chairperson, Madam Commissioner, is the Poor Man building at 29 and 31 Hunts Street in Jeppestown. The fire took place over the weekend. It seems to have arisen in one shack at the building, but then spread and damaged a number of other shacks on one of the upper floors. The residents have moved back in. They're on the ground floor, and among themselves they're organizing in terms of providing accommodation so that everyone has a place to stay. There was attention from the city. EMS assisted to extinguish the fire, and there was coordination through the city and the local councillor and the aid agencies of the provision of food and blankets over the weekend. So that's what we're aware of at this stage. Colleagues from the SERI team and from ICF are at the building today and awaiting further assistance and engagement from the city. So that is the situation, and as I indicate, we'll provide more details when we have them. Happily, there were no injuries or fatalities arising from this incident.
Yes.
That's the report we've had. Chairperson, Madam Commissioner, if I may then move to deal with the matter of our opening statement.
Yes,
if it's
you may.
convenient. I should place on record that I appear with my learned friend, Mr. Tobakale, and that our statement was prepared by the two of us with the assistance of Mr. Skosana, who is a pupil member currently making his way through the bar exams as we speak.
It's nice to see Mr. Tobakale. We last heard him when we were arguing about whether cameras should be admitted at the inspection or not.
Indeed, Chairperson and Commissioner, I will indicate that when it comes to leading the SERI and ICF witnesses, Mr. Tobakale and I will be sharing that task,
Okay.
and he will be leading some of the witnesses
Yes.
on our side. Chairperson and Madam Commissioner, we've also now had regard to the initial opening address on behalf of the city, and I'll endeavour to respond to that where appropriate in relation to the scope of the terms of reference and the approach of the Commission. We are grateful, Chairperson and Madam Commissioner, and to the evidence leaders for this opportunity to deliver opening statements. We think that it comes at a valuable time in the life of the Commission and its work, an opportunity for all of us to pause, reflect on the work that has been done, and the purpose of the Commission and the work that remains to be done. And we have sought to use it for that purpose ourselves. The Commission, as we all know, came about as a result of the tragic deaths and injuries of residents at Usindiso building. So at a very simple level, it arose from that single tragedy, from one fire, and as emerged during that evidence, from a single act of arson. But as this Commission of Inquiry discovered during the course of part one of the proceedings, the causes of the deaths, the causes of the situation at the building were much deeper and more systemic than a single fire or a single criminal act. And we're now in part two of the proceedings, which has its roots in that single incident, that single tragedy, but requires us to face systemic questions. In part one, as the Commission is very well aware, the Commission of Inquiry ultimately issued a report and made a series of findings, at the heart of which was a systemic failure to enforce bylaws that have as their purpose to preserve the safety and the rights of residents of inner city buildings. We also, we submit, found in part one of the proceedings systemic violations of the socioeconomic rights of the residents of the Usindiso building. In our submission, that was the essence of the part one findings, which go much beyond a single fire and a single act of arson. In our opening submissions, Madam Chairperson and Commissioner, we propose to deal with the following 5 issues: the interpretation of the terms of reference, which my learned friend Mr. Koza has addressed you on a moment ago, the current status of the evidence in part 2, what evidence is currently before the Commission relevant to part 2. The third issue is an outline of the evidence which SERI and the ICF intend to lead under part 2. The fourth issue is an overview of the sorts of findings and recommendations that we have indicated at this stage that we intend to propose. Those may, of course, change in light of other evidence that emerges, but what we've proposed at this stage. And finally, and crucially, our submissions on the evidence which we submit the city ought to be expected to place before the Commission, before the closure of proceedings, in order for the purpose of the Commission to be fulfilled. So if I may begin with the terms of reference, Chairperson and Madam Commissioner. And you've heard Mr. Koza's submission on those. And these have also been the subject of some engagement between the parties and the evidence leaders, the participants and the evidence leaders during the course of the proceedings. We've set out the terms of reference in our opening statement, in which part 2 directs this Commission to inquire with expedition into the circumstances surrounding, and it's important, I submit, to quote the language in full. Generally, the prevalence of buildings or removable properties in the Johannesburg Central Business District, Region F, being abandoned by their legitimate landlords or owners and taken over by criminal syndicates or other groups and leased out to and populated with tenants who do not have the means to afford other forms of housing without providing basic services such as water, electricity, refuse removal and sanitation, and paying rates and taxes. And then those buildings are defined as the so-called hijacked buildings. And B, in the light of the above circumstances, make findings as to who must shoulder the liability or responsibility for the said state of affairs, deaths and injuries. And Chairperson, Madam Commissioner, you will recall that at the close of part 1, we made submissions on the interpretation of those terms, liability or responsibility, and we stand by those submissions. The same terms are used in part 1 and part 2, liability and responsibility. And then C, the Commission is mandated to draw lessons from these circumstances and taking account of the said investigations by the SAPs and other relevant competent authorities make recommendations insofar as, 1, the appropriate steps that must be taken and by whom, and 2, any other matter that the Commission considers necessary or appropriate to address any relevant matter arising in relation to this clause. Chairperson, we submit that it requires some care and attention to the text, the context, and the purpose of the Commission to understand those terms of reference, their scope, and the powers of the Commission. And Chairperson, if I may, my learned friend Mr. Koza did read most of Part 2 to you, but he then resorted to using the term hijacked buildings. And we submit that that term can be misleading in this context because the term has been defined in Part 2. And it's the actual text of paragraph 2, sub 2, of the terms of reference that gives the Commission its powers, its scope, rather than what might be an understanding of hijacked buildings that might exist outside this Commission. So we need to go back to the text, the elements of that Part 2. And we start, Chairperson, Madam Commissioner, with the reference to the buildings having been abandoned. That's the first clear requirement for the direct scope of the terms of reference. Not hijacked, that's a definition that comes at the end, but abandoned. So abandoned by their legitimate landlords or owners. That's the first element. And the second element is that the buildings have been taken over by criminal syndicates or, importantly, other groups. It's a well-established principle of statutory interpretation that where two different terms are used, they must be interpreted to mean distinct things. So criminal syndicates and other groups are different terms. They mean different entities. The criminal syndicates phrase clearly connotes criminality, whereas the other groups reference is neutral. It has nothing to do with criminality, and it can include groups of people who are not engaged in any kind of criminality. This would include in our submission people who simply occupy buildings, so building occupiers. That occupation may be unlawful under the PI Act, but it is not criminal conduct in and of itself. And so those other groups would include occupiers, lawful or unlawful. Chairperson, Madam Commissioner, the terms of reference then go on to refer to these buildings which have been abandoned and taken over either by criminal syndicates or by other groups, taken over and occupied, being leased out to and populated with tenants. So there is an element of leasing and being populated by tenants, but the terms of reference specify what kind of tenants we are concerned with. These are tenants who do not have the means to afford other forms of housing. So we're talking about poor tenants who are unable to afford other housing apart from the buildings that have been occupied. And there's one further element which we submit as important, which is the remaining phrase, without providing basic services such as water, electricity, refuse removal, and sanitation, and paying rates and taxes. So the terms of reference have specifically emphasized that we're concerned with buildings that may not have the full range of basic services and where tenants may not be paying rates and taxes, which is again congruent with the fact that we are concerned with tenants who can't afford other housing. So, Chairperson, we emphasize the point that although the term hijacked buildings is tucked in at the end as a definition, as a sort of shorthand for these buildings that have been described in detail, in fact, the terms of reference recognize that the people who live in those buildings are often poor people who cannot afford other forms of housing and who do not have access to water, electricity, refuse removal, and sanitation. Chairperson, Madam Commissioner, we also draw assistance from the context in understanding the terms of reference, because it's important not to simply have regard to that text that I've been focusing on in an abstract way. And there are several factors of context that are relevant. The first is that, as I began my submissions, this Commission of Inquiry has its roots in the original tragedy at the Usindiso building. The circumstances that led to that tragedy, the fire, the loss of life, the conditions in which the people lived, their history as residents of that building. Also important context is that the question of abandonment of buildings, and we further refer in paragraph 9.4 to the preamble to the terms of reference, which allows us to take a step back and understand why the Premier appointed the Commission, the primary purpose. Because the terms of reference record the following as the purpose of its appointment, and I quote, "And recognizing that the Gauteng provincial government seeks a comprehensive overhaul of all the underlying issues that place the dignity, health, and well-being and lives of the residents of the province of Gauteng in danger, and considers the appointment of a Commission of Inquiry to inquire into the circumstances surrounding the prevalence of said buildings or removable properties." And then if I move beyond to the next emphasized part, at the end of the quote in 9.4, "to ensure that tragedies like the one at the Usindiso building never happen again." So that was the underlying purpose. It was the provincial government recognizing the need for a comprehensive overhaul, and a concern with the dignity, health, and well-being and lives of residents of the province, to ensure that such a tragedy never happens again. Chairperson, part of the context as emerged during the Part 1 inquiry was that the Usindiso building was marred with allegations of criminality by some, but by no means all residents. And the people who lived in that building did not have access to basic services at key points in their occupation. Chairperson, those we submit are valuable contextual factors. Then finally, if we sum up on what we submit as the purpose of the terms of reference in relation to this second stage of the inquiry. The first part of the purpose comes from the preamble, that there should never again be such a tragedy. The second part of the purpose is what the Gauteng provincial government envisages as a comprehensive overhaul of the underlying issues that places the dignity, health, and well-being and lives of Gauteng residents in danger. So, Chairperson, that is the scope of the inquiry. I will, perhaps it's helpful here then to say a couple of things. Well, let me sum up on the purpose, and then I'll come back to what that means for the scope and respond to Mr. Khoza. Having regard to that purpose, that never again purpose, no such tragedy, and the comprehensive overhaul of the underlying issues, the Commission is empowered to make findings on liability and responsibility for the state of affairs that emerges from its inquiry, and to identify lessons to be drawn and to make recommendations. And Chairperson, I'll recall that the text of the terms of reference provides that those recommendations may cover appropriate steps that must be taken and by whom, and any other matter that the Commission considers necessary or appropriate to address any relevant matter arising in relation to this clause. So we will submit that the Commission has fairly far-reaching powers in relation to making recommendations. Certainly, Chairperson, Madam Commissioner, the terms of reference do not say that the Commission may only make recommendations in relation to buildings that fall strictly within the direct scope of Part 2. The powers are broader than that. There are powers to make recommendations on any matter relevant to any issue that has come before the Commission. So, Chairperson, if I might then just capture what we say is the direct scope of the buildings that are covered, and then the broader scope of what is appropriate for the Commission to consider and its powers. The direct scope are the buildings that have the characteristics defined in the terms of reference. And we set these out at paragraph 11 of our opening statement. So these are buildings that have been, 1, abandoned by legitimate landlords or owners, 2, taken over by criminal syndicates or, and we emphasize, or other groups. It does not need to be criminal syndicates. 3, leased out to and populated with tenants who do not or cannot afford other means of housing. And the 4th element is without providing basic services and without paying rates and taxes. Now, we submit that those first 3 elements really capture the scope, the direct scope of the buildings that should be front and center in the focus of the Commission. Abandoned buildings, occupied by criminal syndicates or other groups, and leased out to and populated by tenants who can't afford other housing and who may not have access to basic services. And arising out of that, the Commission is empowered to make findings on liability and responsibility and then make recommendations. But, Chairperson, it's here that it's appropriate for me to respond to Mr. Khoza. And we'll make a couple of submissions in this regard. Let me first deal with the issue of TEA. The Commission has inspected some TEA buildings and has had regard to other TEA that may or may not be available, that is operated by the city currently. Technically, some of that TEA may not meet the criteria of the direct scope of the terms of reference, but the existence, conditions, and availability of that TEA is directly relevant, inescapably relevant to this Commission of Inquiry's function. And so it's entirely appropriate that the Commission has regard to what TEA is currently available, what more may be made available. There is no way that the Commission, in our respectful submission, could complete its function without some inquiry into the availability of alternative accommodation. Just this morning, my learned friend Ms. Platt placed before the Commission 2 further concluding reports in relation to buildings. And in relation to one of those, there is again a recommendation of alternative accommodation, or TEA, being sought. So those issues are clearly relevant and clearly within the scope of and purpose of the Commission. Chairperson, there may also be other buildings that the Commission has investigated or that it is more broadly aware of, arising out of expert evidence or other evidence, that don't meet the criteria of the focused buildings, the buildings that are squarely within the direct scope of Part 2 of the terms. But that does not make those buildings irrelevant to this Commission's purpose. And it does not make it inappropriate for the Commission to have regard to the broader context or to other buildings that reveal similar challenges or similar issues. And these are questions that we will return to in closing argument and in the course of our evidence. But it was necessary for me to give a preliminary response to my learned friend, Mr. Khoza, to indicate that this Commission should not consider itself unduly hamstrung to feel that the only buildings that it can have any regard to or make any findings or recommendations on are those that have the criteria in Roman numeral 2. The Commission's purpose is broader than that. The provincial government calls on this Commission to make recommendations that assist it in a comprehensive overhaul of the underlying issues and to avoid a repeat of the tragedy. Chairperson, Commissioner, perhaps that's one further, that repeat of the tragedy is one further illustration of why an unduly narrow approach would be inappropriate. If the Commission has, in the course of its inspections, identified a building that poses a fire risk to the residents, an immediate, imminent fire risk, this Commission would, with respect, be falling short of its mandate if it decided to say nothing about that building because, for example, rental is not being paid, or because an owner has reappeared and so the building is arguably not abandoned. The central purpose of this building is to address the systemic crisis and to prevent a repeat of the tragedy. And an unduly rigid approach to the terms of reference is not going to assist in that, and in any event is not the correct approach in law, as we've endeavored to show with our unpacking of the terms of reference. Chairperson, those then are our submissions on the terms of reference. And it's on the basis of that approach that we have prepared to engage further in part 2 of the proceedings. The next issue that we address in our opening statement, in terms of taking stock of where we are, is the current status of evidence. What does the Commission have before it at this stage in terms of relevant evidence for part 2? And Chairperson, Madam Commissioner, we identify the following broad categories. Of course, the evidence gleaned from the inspections of over 100 buildings conducted by the Commission. In addition, and sorry, I skipped over the first category. This is 12.1. All the evidence led in part 1 that went beyond the specific circumstances of Usindiso building and that is relevant to part 2. And then the third category of evidence, which is still being placed before the Commission, consists of statements received specifically for the purposes of part 2, including the statements provided by SERI and the ICF, and by other participants in the Commission, which will in due course be supplemented by oral evidence. Chairperson, if I may then address the issue of the part 1 evidence, because it seems to us that this is important.
Yes, I would like to hear you on that one.
Chairperson, our understanding of the terms of reference is that a single commission was appointed with ultimately a single mandate, but divided into 2 parts, with the first part being focused on the Usindiso building and requiring the Commission, as it did, to issue a report at the conclusion of part 1 focused on the building and all that went on there. But we submit, Chairperson, Madam Commissioner, that there is no hermetic seal between the evidence that was led in part 1 and part 2. Much of the evidence led in part 1 was relevant to part 2, and we submit that it should be taken into account in part 2. We highlight a few instances, and we submit that of particular relevance will be evidence of witnesses such as the then mayor of the city of Johannesburg, Mr. Gwamanda, the executive director, Human Settlements, Mr. Patrick Poppy, the acting fire chief, Mr. Monageng, the chief executive officer of the Johannesburg Property Company, Ms. Helen Boertes, and others. We highlight those, but they're not meant to be a closed list. The point, Chairperson, is that those witnesses, when they testified, gave evidence on the building and what was done in relation to the building, but also gave evidence on the broader context, the context of policy, the context of implementation by the city, and how the particular building fell within that context. What else was being done or not done by the city, by EMS, and so on. And their testimony, too, went to some of these systemic issues. We can, just by way of illustration, Chairperson, Madam Commissioner, there was engagement with Mr. Monageng, the acting fire chief, around the possibility of fire safety training in other buildings beyond Usindiso building, which was a suggestion that Mr. Monageng welcomed, and in respect of which he indicated a willingness to work with the ICF in providing that training. But that's just one example, Chairperson, to illustrate that there is evidence that this Commission has received that took time and effort on the part of the city and others to procure that is directly relevant to Part 2 and that we submit ought to be taken into account. There is no indication in the terms of reference, textually or otherwise, that the evidence in Part 1 is somehow meant to be hived off and kept separate from Part 2. We submit that the Commission should better be understood as engaging in a rolling process, an iterative process, where it focused on the building in first Part 1, but began to gather valuable evidence about the broader context of the city, which now laid a foundation for the Part 2 inquiry, which has been supplemented by the inspections and by the evidence yet to come. So our submission is that that evidence is already admitted, it is before the Commission, all the parties have it, and where appropriate should engage with it. I will in due course deal with areas in which we submit that evidence, especially on the part of the city, is deficient. There are key gaps that need to be filled, but I'll deal with that separately. For now, the submission is made that the evidence in Part 1 is admissible and relevant. If I may then touch on the inspections, we want to place on record first publicly the substantial effort by the members of the Commission, the evidence leaders and other participants to conduct those inspections. And perhaps the public should be aware of the time and energy and work that went into visiting the buildings and the sites by the chairperson, commissioner and evidence leaders, seeing the buildings firsthand, engaging with residents of those buildings and seeing how they live and the challenges that they face. So we place that on record now at this opportunity. And we acknowledge that those inspections of over 100 buildings to which we have responded, we've responded to all of the building reports, now constitute a substantial sample of the buildings that fall within the terms of reference and other buildings, such as TEA, and I've addressed that issue, that may not fall within the terms of reference but are vitally relevant to the purpose of the Commission and to this inquiry. So we have now a substantial sample from which trends can be drawn, from which problems can be identified. SERI and the ICF sought to contribute to this process of inspections by identifying buildings that we submitted were appropriate for inspection, and we identified the initial 12 buildings which we submitted highlighted particular trends and issues and were illustrative of the broader class. We have also responded as SERI and the ICF to the draft building inspection reports prepared by the evidence leaders. Chairperson, Madam Commissioner, we will address this evidence more fully during closing argument on individual buildings and recommendations in relation to them. But at this stage, at a higher level, we want to highlight that the inspections in our submission have already confirmed the following trends relevant to Part 2. And we set these out at paragraph 15 of our written opening statement. First, a significant number of buildings have been abandoned in various ways and following different stories by their owners and are unlawfully occupied in terms of the PI Act. These buildings are generally occupied by poor residents who are unable to afford other accommodation. So those are the first two elements really of the terms of reference. Those residents have not been assisted with other housing by the city. The third trend that we submit emerges is that there is overcrowding in many of these buildings, insufficient fire equipment, inadequate fire safety planning, including escape routes and other issues in many of these buildings, as well as the use of flammable building materials, which was a concern that arose and to which particular attention was paid in some of the inspections. It also emerged very clearly that many of these buildings lack basic services, especially water and electricity, and often also sanitation. But we emphasize water and electricity because of their impact on safety. And finally, it did emerge that some buildings may have structural deficiencies that create safety risks. Chairperson, Madam Commissioner, as we noted in our first response, and this was echoed in our later responses to the draft inspection reports, the inspection reports by their nature are provisional in certain respects. Given that it has not yet been possible or practicable to receive direct input from the residents of each of these buildings on the issues, or crucially to have assessments by a structural engineer of those buildings where there are concerns about structural deficiencies. That renders some of those findings provisional in certain respects, and That has a bearing on appropriate recommendations in due course, which we have addressed in our response to the inspection reports and will address further in closing argument. But despite those perhaps inevitable limitations, the inspection reports have identified, we submit, fairly conclusively at this stage, where particular buildings may be overcrowded or have building materials that create fire risks, where buildings lack fire equipment and adequate fire escapes, where buildings lack basic services such as water and electricity, which is a rights violation on its own, but also aggravates the fire risks, and where other upgrades or infrastructure repairs are necessary even without a structural engineer assessment. And Commissioner Chairperson, you'll recall buildings, for example, where stairwells are open and it's possible to fall over into those areas, where lift shafts present risks, those sorts of issues, where there are obvious glaring safety risks. Chairperson, to conclude then on this point, what the inspections have shown, we submit, is that there is a need for interventions in the short term on these issues of fire safety and basic services in particular, as well as those aspects of infrastructure that create immediate risks and can be repaired immediately. We make the submission, Chairperson, Madam Commissioner, that even if at the end of this commission there may be some recommendations that people should be relocated to other accommodation, that is going to take substantial time. Even where buildings are identified as particular high priority for relocations, we know from experience, and it's apparent from the inspections and from all the evidence this commission has seen, that that doesn't happen quickly. And so we will submit that interventions to mitigate fire risks, improve infrastructure, and provide basic services are urgent, and we're highlighting that at this stage. It's our submission that those issues lie at the heart of the Part 2 inquiry, those issues of fire risks, basic services, and immediate infrastructure dangers. And it's with regard to those risks and issues too that SERI and the ICF have identified relevant evidence which, with respect, we intend to place before the Commission as facilitated and coordinated by the evidence leaders. Chairperson, the next section of our opening statement provides an overview of the evidence that we propose to lead, and we're engaging with the Secretariat and the evidence leaders around the exact dates when that evidence will be led. But Chairperson, Madam Commissioner, that evidence, which will of course be led from the perspective of SERI and the ICF and from the perspective of the people who live in the buildings which fall under Part 2, really falls in three categories, and I'll highlight and give an overview of those categories. There is evidence from SERI and ICF itself in the form of the statement of SERI's Executive Director, Ms. Zondo, as confirmed by SERI's Director of Research and Advocacy, Ms. Royston. There is the main statement of the ICF of Mr. Mahlangu. So we have that category, those two primary statements. They're lengthy statements with annexures and quite detailed. There is then the evidence of individual residents, and we have sought not to overburden the Commission with many, many residents' affidavits, but as we did with selecting 12 buildings, to identify residents whose experiences typify the lives and challenges of residents of the buildings in the inner city. And so there will be a category of those statements where evidence of individual occupier witnesses will be led. And then finally, there's certain expert evidence which relates to the broader policy framework and the broader context of implementation. Chairperson, our written statement provides an overview of the SERI evidence, which really is captured in that rather lengthy SERI statement of Ms. Zondo. Chairperson and Commissioner, you are by now familiar with SERI and its work and experience and interest in these issues. I just highlight again that SERI has been working with inner city occupiers for 14 years, that SERI has represented residents of over 80 buildings. We actually think that's an underestimate, and consulted with residents of at least 100 buildings in the inner city of Johannesburg alone, and currently represents residents of 37 properties that we say fall within Part 2. And we've provided that list to the Commission. Chairperson SERI has also had experience of working with residents in the city's TEA. In fact, SERI represents residents living in most of the city's TEA facilities, as well as experience with tenants facing rental disputes, and even a handful of matters representing people who own the properties in which they reside, but that is unusual in our work. Chairperson, Madam Commissioner, our evidence in the SERI statement really focuses initially with an overview of the policies and programs that the city has implemented in the inner city from around 1991, and in particular from about 1996. And we submit that evidence will show that the city has been aware of the problems of the inner city since that time, for over 30 years, and has attempted to address it in its policies in certain ways since the 1990s. We trace the evolution of those policies in quite a lot of detail, and Chairperson, Madam Commissioner, we're in the process of putting together a bundle for the convenience of the Commission of those policies as well as any relevant laws that we will rely on later. And we'll have that bundle by the time we lead this evidence. We say that evidence will show that the city has been largely unsuccessful in implementing those policies since the 1990s, that its concept of regeneration, which is one of the central features of those policies over the years, involving partnership with the private sector, has failed to cater for poor people living in the inner city, and that the city's policies and programs do not account for people who currently reside in occupied buildings. Chairperson, we will focus on two particular policies over that decades of policy change. One is a policy adopted by the city of Johannesburg, and one is a national policy. The city's policy on which we'll focus, and we'll lead one of our experts on this, is the Inner City Housing Implementation Plan, ICHIP, which was adopted by the mayoral committee, but not approved by council, as we understand it. A great deal of work, effort, money, resources went into developing ICHIP. And we will lead evidence to show that ICHIP did take seriously the problems of the inner city and offered what we will submit are some viable options to address the housing crisis of the inner city. But for reasons that we are not aware of, ICHIP was not ultimately implemented. And so we'll deal in some detail with ICHIP, because we submit that at the level of policy, it does offer guidance to this commission. It was commissioned by the city itself at great expense and adopted by the mayoral council. So it's not something coming from outside. So ICHIP we highlight. The second, Chairperson and Madam Commissioner, is the National Emergency Housing Program. And we'll trace its history. It originates, Chairperson, as you are well aware, no doubt, from the decision of the Constitutional Court in Grootboom. Grootboom ultimately found the state's housing policy unconstitutional for failing to provide for those in the most desperate circumstances. That led to the National Housing Code, which contains the emergency housing program. So it arises directly from the Constitution and from the Grootboom decision. It's a national policy that applies to all metropolitan municipalities, including the city. It provides a policy framework and a source of funding. And it deals specifically, under the definition of emergencies, with precisely the sorts of evictions and threatened evictions that this commission has been looking at. So we will emphasize those two policies, ICHIP and the EHP. Chairperson, as you and Commissioner Mabena will have observed from the SERI statement, it also then traces the development of the law. Now, we're well aware that the commissioners and our colleagues can read the cases, and those are a matter for argument. But what we've sought to do in the statement is to tell the story of what was happening as the law developed and how the city was implementing it as events unfolded, as well as what occupiers were experiencing during this time. For example, Chairperson, we will highlight the events surrounding the Olivia Road period and what was happening then, including waves of police raids and so on that were ultimately brought to an end fundamentally by the Olivia Road decision. And we'll highlight the events around the Gladla case, which at the time was a controversy around what kind of alternative accommodation is required. And as a result of that, the city stayed all eviction applications, or all the large ones that were before the courts, and basically suspended the provision of TEA, so that things went into a lull for an extended period. And those are the stories or the narrative that we will trace, and how it affected residents of the inner city through those major court decisions, including, Chairperson, the decisions in Peko and Schubert Park, which confirmed that even where there is an evacuation on the basis of health and safety, a person may not be evicted circumventing the PI Act, and where they are removed for health and safety reasons, alternative accommodation must still be provided. So those are some of the key features that we will deal with around the development of the law. The next part of the SERI statement, Chairperson, that we will foreshadow arises from independent research of a qualitative and quantitative nature conducted by SERI's research team, led by Ms. Royston, and that evidence will be led through Ms. Royston in due course in her testimony. And it arises from a series of data sets and research projects conducted by SERI over different periods. The first part deals with housing of affordability in the inner city, what housing is available for poor residents at what economic levels, based on surveys conducted over a decade of experience. The second data set concerns life experiences of occupiers in the inner city. This is qualitative research, and it relies on both on data sets prepared by SERI as well as data procured from other sources, including the Gauteng City Region Observatory and their data. And Chairperson, the third major set of data there relies on a survey conducted by SERI one-to-one and the ICF in 2023, so last year, and that's concerned with basic services, access to basic services, and it focused on 23 buildings. And we submit that all of that data will complement the data gleaned from the inspections and other evidence led to assist this Commission with respect to make findings in relation to those issues of housing affordability, what is available on the market, the experiences of occupiers in the inner city, and the availability of basic services. Chairperson, the last piece of that research-based evidence concerns the unique experiences of women living in the inner city. And Chairperson, this will draw on the research and experience of SERI in working with women clients, women-headed households, and women leaders, many of whom, Chairperson and Madam Commissioner, you met during the inspections. Chairperson, then to provide an overview of the ICF evidence, again, the Commission is now familiar with ICF and its history and establishment and how it works to organize inner city occupiers in over 40 buildings in the inner city, again, including many that the Commission has visited and inspected. And Chairperson, Madam Commissioner, the ICF's evidence will focus on the ICF's knowledge and experience of the history of the inner city, a specific sample of 12 buildings which fall within the terms of reference. Those were the 12 buildings that we proposed for inspection. And the ICF statement deals with the history of their occupation, the struggles of those, the residents of those buildings to access basic services, the conditions in which they live, any legal proceedings, evictions, and so on. And the third aspect that the ICF focuses on, drawing on its experience, is the poor management of TEA that has been provided. Again, the Commission has seen some of that firsthand already. Chairperson, emerging out of the ICF evidence, linked to it, the evidence of the individual residents that we will lead will deal with where they came from. Many of them came from outside Johannesburg. How did they come to live in the inner city? How did they come to reside at the particular properties? Were they evicted previously and have they been moved around? How they make a living and survive in Johannesburg, and why they cannot live elsewhere, why other better accommodation is not available to them, why it's not an option for them. Chairperson, our evidence will also, drawing on those individual experiences and the evidence of the ICF, will highlight that people who live in occupied buildings are often criminalized, be it in the media, social media, the statements of irresponsible public figures. And Chairperson, it's for that reason, linking back to my submissions on the terms of reference, that care must be taken not to stick on that term of hijacked buildings, which is a definition tucked into the end of the terms of reference, when the terms of reference actually focus on abandoned buildings, people who cannot afford other housing, lack of basic services. And the unfortunate consequence of that use of the word hijacked buildings is to criminalize all of the people who live in the inner city when it is inappropriately used. And Chairperson, the evidence of the ICF will highlight that at times how authorities deal with residents of inner city buildings, for example, by seeking to take away their rights to privacy and dignity, or by leaving them living without water, sanitation, and electricity, suggests that their being human, that they're human beings, is often forgotten. And Chairperson, we submit with respect that one of the reasons why this evidence of individual residents of buildings is important is for the Commission, for all of us, for everyone watching, for all members of the public, to remember that the residents of the buildings in question are, before anything else, human beings. They are mothers, fathers, sisters, daughters, sons. They're people making a livelihood in the inner city, and that ought to be the starting point. And Chairperson, we find resonance with the preamble to the terms of reference in that regard, where the Premier referred to concern for the dignity, health, well-being and lives of all of the residents of the city of Johannesburg. And we submit that evidence goes to those issues and those concerns. Chairperson, the third and final category of evidence that we will lead is expert evidence. And at this stage, we're in a position to confirm two sets of expert statements. The first is by Professor Benjamin Cousins. Chairperson, Professor Cousins is a professor at the University of the Western Cape at the Institute for Poverty, Land and Agrarian Studies, PLAS. Chairperson, Professor Cousins has given evidence of an expert nature in legal proceedings in many significant cases. And his evidence here will focus on the question of bad buildings, the policy frameworks that could be useful for purposes of addressing bad buildings, the role of collective organization, so how communities organize themselves. Professor Cousins will speak to that, which links to the ICF evidence. And this is probably Professor Cousins' core expertise, how tenure works in South Africa, in law, but also in the lived experience of people in both rural areas and urban areas, which is often, the lived reality is often quite different from the law on the books. How people come to occupy and have tenure in inner city buildings, how those rights are recognized by their fellow residents, and how they organize themselves and, for example, elect committees. And Professor Cousins will offer from his independent perspective what he would suggest are possible policy responses to some of the challenges that we've identified. And I'll highlight, for example, that he speaks to the issue of expropriation and the question of what compensation, if any, may be required for expropriation, an issue that has been topical in our society of late. Chairperson, the second expert statement that we envisage leading is a joint statement by Dr. Tanya Zak and Ms. Sarah Charlton, Professor Sarah Charlton. And in short, Dr. Zak and Professor Charlton were part of the team that prepared iChip. So they did the research that went into developing iChip, working with city officials, and their evidence will focus on iChip. The background to it, what led the city to try to develop this policy, the context in which iChip was developed, the principles that underpin it, many of which are good principles, its financial implications. They cost what it would take to implement different programs of iChip. Those costings, I should highlight, are now somewhat out of date because iChip was adopted in 2017. But they give an indicative costing of what it would take to do certain things in the inner city, such as subsidy programs for rental housing. And Chairperson, ultimately their evidence goes to the significance and relevance of iChip today and for this Commission. Chairperson, I'm conscious that I've eaten into what would usually be a tea break, but I am now fairly close to conclusion.
No, you may proceed. What time is it?
It's 8 minutes past 12, Chairperson.
No, you may proceed.
Thank you, Chairperson. Chairperson, we're conscious that we are doing this in some detail, but we hope that will assist in giving a sense where we are going to go with our evidence and enable everyone to prepare and participate accordingly. Chairperson, at the conclusion of the main SERI statement and also the main ICF statement of Mr. Mahlangu, the deponents to those statements outline certain proposed findings and recommendations, which really come under the lessons to be learnt, findings to be made by the Commission, and recommendations that it might ultimately make. And Chairperson, of course, we've made those proposals without having yet had regard to what other evidence may be led, what may still emerge during Part 2, and it may be that we make some changes to the final findings and recommendations that are proposed. In fact, it's likely in reality. But I would highlight that the findings that we envisage at this stage include that the city's policies and their implementation up to this point have been insufficient to deal with the problem. We submit that is glaring. It emerges very powerfully, I think, from the inspections, but also from the broader inner city context. The second is that not all persons who live in occupied buildings are criminals or building hijackers. In fact, most of them are not criminals or building hijackers. They're people looking for homes and ways to live in the inner city. The finding that some buildings have committees which ensure that there is some form of order, that manage repairs, that try to regularize accounts for the payment of rates with the city, rates and services with the city. And the Commission, with respect, has seen the work of some of these committees firsthand during the inspection phase. And we will submit that there are certain best practices that emerge. There are some buildings that are obviously in a better state, where committees we submit are doing good and valuable work to minimize fire risks, to keep building conditions in a good state. We will submit that there ought to be findings in relation to the basic provision of basic services. In effect, that the city has fallen short even of its own policy commitments in terms of providing basic services, water and electricity, to poor residents of the inner city, on its own policies, which provide for free and subsidized basic services. And finally, crucially, there's a set of findings in relation to TEA, or alternative accommodation. Again, that this TEA is inadequate. The existing TEA has been allowed to deteriorate and fall into poor conditions. It is full and it is insufficient. So, Chairperson, Madam Commissioner, there are a set of issues there around which we will focus. Around terminology and concepts like hijacked buildings, tenure, and so on. Perhaps most fundamentally, the systemic housing crisis that lies at the heart of everything. The importance of location and why people live in the inner city, why they come to live in buildings that may be unsafe, as opposed to remaining where they came from or going somewhere else. And issues of their invisibility, criminalization, being regarded as criminals, and most fundamentally, the non-implementation or failures of implementation of housing and related policies and bylaws that need to be addressed. We anticipate, Chairperson and Madam Commissioner, ultimately arguing that the city must proactively act on its obligations to address these issues for the residents of the inspected buildings and other residents of the inner city. We will focus on the EHP and its potential to provide a policy framework, the Emergency Housing Program, a policy framework and a source of funding. We will also we anticipate making submissions regarding the need for building assessments and categorizations to have clear criteria, including fire risk, and that those categorizations and assessments must be transparent and applied in a participative manner. Chairperson, Madam Commissioner, this really it relates quite closely to how our inspections, this Commission's inspections, were conducted. The city needs to do similar things in terms of auditing the buildings, but that needs to be participative. It needs to work with groupings like the ICF, with building residents, and it needs to have clear criteria that are transparent so that building residents know what they're being assessed for and how they can contribute to that process. We will submit that the city's planning department needs to conduct an audit of vacant and unused buildings that could be potential alternative TEA, further TEA. So what other buildings and vacant properties could be available for that purpose? And finally, there are issues around how the JPC, the Johannesburg Property Company, and other entities of the city manage the existing TEA and city-owned accommodation, the effectiveness of that management. Chairperson, that then is what we envisage. But in order to get there, there is one final piece that I must address. And that is, with respect, what we submit is missing evidence that has not been made available by the city and perhaps to some extent by the province, provincial government, but primarily by the city. Chairperson, you've heard my quite detailed submissions on how SERI has attempted to deal with the city's policies and their implementation by the city. And we will do our best to place that evidence before the Commission. But with respect, Chairperson, Madam Commissioner, there is no entity with better knowledge of the city's policies, plans, and their implementation than the city itself, its office bearers and officials. And we submit, Chairperson, that this additional piece is necessary in order for this Commission to make the most of the enormous work that has been conducted up to this point. Its absence undermines all of the work that has gone into the Commission by everyone so far. All of the hard labor that went into the inspections, all of the documents that have been procured. And so we submit, Chairperson, that with respect, it is not sufficient for the city to stand before you in its opening statement and to address one issue, which is to try to narrow the terms of reference of this Commission of Inquiry. The city, as a responsible organ of state, as the largest and wealthiest metropolitan municipality in this country, needs to present to this Commission its positive plan. And we submit that plan needs to have at least 3 key elements. First, the policies. What policies is the city applying to the buildings that have been inspected? to other similarly situated buildings. Part of that might be to explain why ICHIP was never finally adopted or implemented, but what policies are currently being applied. Secondly, what is its specific plan to deal with the buildings that the Commission has inspected at great cost, involving great labour, over 100 buildings, in respect of which the evidence leaders have placed summary findings before the Commission? What is the city's plan for those buildings in respect of basic services, in respect of infrastructure, in respect of alternative accommodation where relocation is recommended? And finally, Chairperson and Commissioner, to make all of that possible, what budget has the city allocated towards these different ends, and what budget might it allocate in future? And Chairperson, we had regard once more, we went back to the statement of Mr. Patrick Poppy, the Executive Director of Human Settlements in the city. That's his statement dated 25 July 2024. Mr. Poppy, of course, testified in part 1. Chairperson, Madam Commissioner, that statement really traces the city's TEA program, gives an update of the state of the existing TEA, which is full, and the plans that the city has to address maintenance to some of those TEA properties. But at the end of all of that, Chairperson, and Mr. Poppy, in fairness, identifies the budget allocation towards that TEA, which was at a point 15 million and was reduced last year to 11 million rand. But that budget is allocated to those existing TEA properties. Mr. Poppy goes on to say, Chairperson, and we quote this at paragraph 35, in light of what is set out above, the city's human settlements unit is financially constrained and it would not be able to bear the costs for the repairs, rebuild and conversion of any infrastructure into TEAs. So Chairperson, take for example the building that my learned friend Ms. Platt dealt with earlier in the proceedings today, where there are recommendations in relation to identifying additional TEA, and there have been recommendations in relation to potentially converting properties into TEA. What Mr. Poppy is saying, as we understand it, Chairperson, is that the city's human settlements unit has no budget, no resources at all for any additional TEA. And if we've misunderstood the statement, or if that is not the case, if there's funding elsewhere, which there ought to be, then we submit that the city is required to come and place that before the Commission. Because with respect, Chairperson, Madam Commissioner, we submit, and we do so now, in our opening statement so that there's still time for the city to respond with evidence and argument on these issues, that it is not constitutionally permissible or adequate for the city to say that we have not budgeted, we will not budget, we have no other resources for any other TEA. The existing TEA is full, and there is no budget for anything else, and for the city not to provide a plan or have a plan for the provision of additional TEA. And it goes beyond the TEA, Chairperson. It applies equally to the basic services, the city's own policies to provide subsidized and free basic services. What is the city's plan to do so in relation to the inspected buildings, at the very least? And Chairperson, we haven't cited it in our heads of argument, but you Chairperson, will be very familiar with the decision of the Constitutional Court in Blue Moonlight, which held that it is not permissible for an organ of state to say that it has not budgeted for a particular program or thing, if in the discharge of its constitutional obligations, that organ of state ought to have budgeted for that program or issue. And we will, of course, return to these issues in closing argument, Chairperson, but we raise them now so that there is the opportunity to address them, whether that's proactively on the part of the city and its representatives, whether it's through the exercise of the more coercive powers that this Commission has in terms of subpoena and requiring evidence. And we acknowledge, as we have observed, the efforts of the evidence leaders repeatedly to request the city to provide additional evidence and information. And it's our respectful submission, Chairperson, that those requests have in general not been met satisfactorily. although I'm sure our learned friends for the evidence leaders will address their requests and their issues themselves. We make our observation. So, Chairperson, we've submitted that at the very least, the city should be expected to provide evidence pertaining to the following issues. Has the city implemented the emergency housing program? Has it triggered that EHP and used it? If so, and we're not aware that it has, when and how? If not, why has it not? It's a national policy with additional funding potentially available. And Mr. Poppy addresses the existence of the EHP in his statement, but says nothing about whether the city has applied it. Secondly, what are the budget allocations? And I've dealt with that issue. But for refurbishment, repair, and infrastructure upgrades of inner city buildings. If there is no existing budget allocation, what allocation might be made, either in the current financial year or the next financial year, to address refurbishment, repair, and infrastructure upgrades, at the very least, of the buildings actually owned by the city. And many of the inspected buildings are owned by the city. The third issue is around provision of basic services. What has the city done? What is its plan? And then the final one, which I've highlighted, is what is the budget for emergency accommodation outside the existing TEAs? Mr. Poppy says there is none. What additional resources are available? Chairperson, we submit that in order for this commission to fulfill its vital task, that additional evidence and information is required from the City of Johannesburg, or where relevant from the provincial government during part 2 of the proceedings, before conclusion, with sufficient time to allow other participants to engage with that evidence and to allow the Commission to engage with it. Chairperson, for our part, SERI and the ICF look forward to the opportunity to participate in part 2 of the inquiry, which we shall do earnestly and to the best of our ability to support the vital work of this Commission, to support the work that the evidence leaders too have done. And we've made the submission, Chairperson, that the Commission comes at a crucial time in the life of our city and its people. And the Commission heard this morning that over the weekend another fire took place, fortunately without loss of life on this occasion. But this Commission has a vital purpose to ensure that the tragedy of Usindiso building never repeats itself, but also that the living conditions of the people of the city, the systemic housing crisis, is confronted. It's not an easy task, and we don't pretend that it is. But the Commission we submit is well placed to make valuable findings and recommendations that go to addressing that systemic housing crisis. Chairperson, Madam Commissioner, that then is our opening statement, unless there are any questions from yourselves.
Thank you very much, Mr. Brickhill, for your comprehensive opening statement. Just one thing. In the light of the roadmap that you have mapped out in your opening submission, how much time will you require in respect of the evidence you intend to lead before this commission? Can you estimate?
Chairperson, the evidence leaders and the Secretariat have engaged with us on that and had allocated us 5 days, which appeared to us, we think that we can do our best to work within that 5 days, and we're planning on that basis. Of course, issues such as further questioning or cross-examination may extend, but we think that 5 days is not far off. We might need 1 extra day if we run a little bit over, but we're doing our best to work within that allocation.
Okay, thank you. Mr. Siminya.
Chair, Madam Commissioner, we wanted to say that it cannot be open for the city to lie supine on matters that it has been aware were principal triggers to this urban decay. We are aware of it since 24 years ago. And today, when you look at the inputs they make into the reports, it's nothing. Mr. Brickhill under paragraph 33 does something also by saying there is missing evidence. I would request, Chair, that you give a direction. The one that says ICF and SERI must engage with MNS to put names and faces to the evidence that would cover the issues they raise under paragraph 33, i.e., what budget allocation has been made for a resolution of these problems. It should not be left at the level of concept. I think with your direction, Chair, if you can enjoin both of them to put face and name to whoever is in the city who must answer to these things, but even more importantly, enable us to have prior sight of those statements before we deal with them. It's very constraining to deal with matters on a rolling basis as we do.
Yes. Mr. Khoza?
Chairperson, the city is here to assist the Commission, and to the extent that there is further evidence that's required to be produced, the city is happy to cooperate and assemble that information within the appropriate timelines. I agree with SC that perhaps there must be a meeting between ourselves and SERI to discuss the issues that they expect to be covered in evidence. Then we can see
Yes.
how that can be accommodated.
So you have no problems with me making a directive that you and ICF should meet and tell us what kind of evidence will be led in respect of that?
In principle, there is no objection to that. However, I think it's important that there be an agreement if we can find each other on the mandates of the Commission, because as I've said, our view is that the Commission is confined to the parameters of as set out in the terms of reference, and it appears from the opening statement from my colleague that as they understand the scope, it's quite extensive. It's not only concerned with hijacked buildings as discussed, as outlined in the terms of reference, but we are seemingly going to be dealing with all buildings that have been inspected to the extent that there are challenges in those buildings. So for us to be able to meaningfully cooperate, if there could be a further discussion in terms of what issues fall within the scope of this commission, that will then give guidance to us, because as we say, we understand the scope of this commission differently. And perhaps with your leave, Chairperson, there's just one issue that I would like to bring to our attention to further articulate our point. I have in front of me a response by SERI and ICF to the commission, to the evidence leaders. This report was, these are SERI's comments on the inspection report issued by the evidence leaders. So it's 3 paragraphs that I'd like to read, 2 paragraphs. They relate to the building named 32 Lake Street, Central Park.
How is it related to the issue that I've just posed to you?
I'm going to address the issue. I just want to set context as to what we think may present potential challenges, Chairperson, if you allow me. So it says, we have considered the draft report of the in-local inspection of Central Park, and now preliminary responses are set out below. The residents of the Central Park are not represented or organized by SERI or ICF. The draft report finds that the building is unsuitable for human habitation because, inter alia, the risk of collapse cannot be ruled out. Paragraph 2, notably, the report records that the property does not, highlighted, the property does not engage the element of being hijacked or taken over, as it is managed or under a sectional title arrangement and the property is leased out and provides basic services such as water and electricity. The draft report does not indicate whether, in light of these facts determined by the evidence leaders, the property falls within the Commission's terms of reference or whether it is excluded therefrom. We submit that based on the factual findings of the evidence leaders, the building falls out of the terms of reference and any recommendations in the draft report are beyond the scope of the Commission's work and should be removed. So this is a position by SERI which aligns with us, where they were saying there is this building that's been inspected. On the face of it, the building is not suitable for human occupation. SERI then says, however, this building does not fall within the terms of reference and the Commission cannot make recommendations. So today, SERI is now making is adopting a different stance, where in essence they are saying the Commission has authority to deal with all buildings that have been inspected, even if those buildings do not strictly fall within the terms of reference outlined in the Commission. So all along we thought at least there is consensus on the parties that there is a specific, there are specific terms of reference which restrict the mandate of this Commission. If we now expand the purpose of this Commission, we then have to be to go back to the drawing board and see exactly with this new expanded scope, which evidence then becomes relevant and within which timelines will we be able to hold consultations and be able to assemble all this evidence. The last thing we want is to undertake to have witnesses within the course of October, only to find that perhaps we're unable to do so because with this now new expanded scope, we are required to conduct extensive consultations, which were not anticipated.
Yes, Mr. Khoza, I still don't understand the relevance of what you've quoted to what Mr. Siminya has proposed that I make a directive on.
Chairperson, the narrow point I sought to make is this. We are prepared to sit down with SERI and to see which witnesses will be relevant. However, we
Yes.
think it may be difficult to do so if we are not aligned as to which issues this Commission is empowered to deal with.
But you are prepared to facilitate the work of the Commission to sit down with SERI ICF to identify the missing evidence
Yes,
they've averted to?
yes.
Yes.
Thank you, Chairperson.
Yes, Advocate Siminya.
No, after the
Yes.
the direction.
Yes. Mr. Brickhill?
Chairperson, just on the proposed directive, we would be comfortable with such a directive, and without getting bogged down in the debate about the scope of the terms of reference,
Yes.
we would submit that that evidence that we say is missing is required whether there are 50, 70, 90, or 100 buildings that fall within the direct scope of the terms of reference, ultimately. Because if there's even one building where the recommendation is the people need to be provided with alternative accommodation, and if Mr. Poppy is saying there is no additional TEA and there's no budget for it,
Yes.
those issues are already relevant, and they have always been relevant. We would also submit that there's been no expansion of the terms of reference. This has always been our position. It's always been clear that the scope of the Commission is as appears from its terms of reference, and that issues of policy, planning, and budgeting have always been relevant, and are crucial to the functioning of this Commission. So, Chairperson, we would be open to that. We note, of course, that we have no powers of compulsion or coercion in relation to the city. We would be entirely beholden to their cooperation. But we would undertake to cooperate in good faith to try to identify what evidence and information and witnesses might be relevant to make those proposals to the city. But ultimately, Chairperson and Madam Commissioner and evidence leaders, with respect, we can't procure them ourselves. That will be out of our power. We'll be able to
Yes.
make suggestions.
Yes. I make the following directive to facilitate the work of the Commission. SERI, ICF, and MNS are directed to meet to identify the missing evidence that has been adverted to by SERI, by Mr. Brickhill in his opening submission, including the identity of the witnesses that MNS must call to give evidence before this commission.
Thank you, Chair. To the extent it may assist MNS, the common thread to the matters the Commission is probing is non-enforcement of bylaws. Now, it can't be a good argument to say there are these buildings which are not obedient to compliance issues, but they fall outside the province of the Commission. But that, Chair, is the business, formal business of the day. We are to meet the COO as well as the head of JMPD in the afternoon.
Maybe I must amend my directive and give an indication as to timelines.
Yes.
Because this is a time-bound commission. What timelines are you suggesting, Mr. Brickhill? There should be a timeline given to when you must meet with MNS.
Chairperson, if I might confirm.
Yes. Mr. Khoza, also apply your mind with regard to timeline. A week or two should be enough.
Chairperson, our suggestion would be that those parties should meet within a week and then should report back to the Commission, say, within 2 weeks from today.
Should report to me within?
2 weeks, so it would give us 1 week. I see my learned friend, Mr. Semenya, shaking his head. Chairperson, this may be an issue on which we could engage if we were to stand down and come to you, Chairperson, with suggested
Yes.
time periods.
Yes, Chair, I can't see why the parties can meet now as we adjourn. Whether logistics require the statements to be acquired in a week is a different matter. But there's no reason why they can't meet now.
Yes.
And decide.
Yes.
Yes.
Mr. Khoza?
Chairperson, we are happy to have a meeting right now and then report to you as to how we intend to proceed. The only difficulty we think we'll face is in relation to securing the actual witnesses. That cannot happen during the course of this week.
Yes,
However,
no.
we can strike agreements.
No, I'm more interested in knowing that the time period during which you have to meet.
We are happy to have that discussion today, Chairperson. Now.
Today?
Yes.
Yes. I think I will amend my direction that the parties are to meet by close of business today to finalize what evidence, what missing evidence must be given. The giving of evidence is a different matter, but the meeting is quite a crucial one that we must give a time period for. We are adjourned for the day.